Good afternoon, Philippines. This is Karin Aguila, and you're watching ABC Live. For the latest international news, Ukrainians defending Mariupol steel plant say Russian forces are storming the facility. For our international celebrity news, the Johnny Depp versus Amber Heard televised defamation trial intensifies and continues as the prosecution rests its case. In sports, the NBA commences playoff semifinals. In the Eastern Conference Game 1, Milwaukee Bucks downs Boston Celtics. In the Western Conference, the Golden State Warriors eliminates Denver Nuggets and proceeds to defeat the Grizzlies in Game 1 semifinals. Meanwhile, LeBron's Lakers is in the lockers as it did not even make it in the play-in tournament. And for our local news, another witness retracts accusations versus De Lima, saying he was coerced. Now, we are down to our last report. This is a follow-up report on People versus Hugueta, which finally comes to a close as the Supreme Court renders its decision to this much-monitored case. Let's hear the report from Corina Sanchez. Corina, can you first refresh us about this case?
Oh yes, Karen, this is the case of People versus Jugueta. In Quezon on June 2002, Irene Jugueta, armed with a caliber .22, was charged with double murder for assaulting and shooting two minors named Mary Grace and Claudine, who suffered two gunshots. On the same date, Irene Jugueta, together with two other men, was charged with multiple attempted murder for attacking, assaulting, and shooting with a firearm caliber .22 the house occupied by the family of Norberto Divina with intent to kill, qualified by treachery with evident premeditation and abuse of superior strength but failed. The trial court ruled against Jigueta, with the Court of Appeals affirmed, but with modifications, that the ordinary aggravating circumstance of dwelling should have been appreciated, and in effect, penalties should be modified. Karin?
Okay, so regarding these penalties, may the court modify the actual or compensatory damages imposed on Hugueta?
Yes, Karen. Although the minimum amount for the award cannot be changed, increasing the amount awarded as civil indemnity can be validly modified and increased by the court. In Article 2206 of the Civil Code, as discussed by the Supreme Court, the amount of damages for death caused by a crime or quasi-delict shall be at least 3,000 pesos, even though there may have been mitigating circumstances. And one of the addition to this is that the defendant shall be liable for the loss of the earning capacity of the deceased, and the indemnity shall be paid to the heirs of the latter. Such indemnity shall in every case be assessed and awarded by the court, unless the deceased, on account of permanent physical disability not caused by the defendant, had no earning capacity at the time of his death. Thus, in this case, in addition to the penalty of imprisonment imposed on Jigueta, he is also ordered to pay the victim a sum of money as restitution. This is Karina Sanchez, live from the Supreme Court grounds, reporting for ABCNN News. Back to you, Karin.
Thank you, Corina. And those are the latest news for this afternoon. Stay tuned and don't dare switch your channels. Oskem Canaba is next up. This is Karin Aguila for ABCNN News.
Ma,
Oo?
ampun po ba ako?
Ha? Sino naman nagsabi sa'yo niyan?
Kasi ma, lagi na akong inaasar sa school eh. Ampun daw ako ma eh.
Anak, di ba sinabi ko sa'yo huwag ka magpapa-apekto sa sinasabi ng iba?
Pero ma, sabihin mo sa akin ma, ampun po ba ako? Ha? Ma! Ampun ba ako? Ha? Ay, paliwanag mo po ma. May paliwanag mo bakit may 4 na baso ko sa likod?
Matagal na namin itinago ito sa'yo, anak. Pero sa palagay ko pa naman ang malaman mo.
Magandang gabi sa ating mga tigapanood. Muli nagbabalik kayo sa ating game show, Game Ka Na Ba? And we are now in our elimination round. And our participants from the outside world, please start giving your answers. The question is, there is material distinction between damages, damage, and injury. The answer to choose from is true or false. Ayan. 6 answered true and no one answered false. So, there is really a material distinction between damages, damage, and injury. Bakit? Bakit kaya? Sino sa ating participants ang gugustuhin sumagot para sa isang BBM poster?
Oyster, kahit ayaw ko yung BBM poster, charot.
Okay. Sige. Oyster, can you explain to us why?
Yes, there is a material distinction between damages, damage, and injury. In injury, it is the legal invasion of a legal right, while damage is the loss, hurt, or harm that results from the injury. On the other hand, damages is the recompense or compensation award for the damage suffered. There can be damage without injury in those instances in which the loss or harm was not the result of a violation of a legal duty. The consequences must be borne by the injured person alone. The law affords no remedy for damages resulting from an act which does not amount to a legal injury or a wrong. In order that a plaintiff may maintain an action for the injuries of which he complains, he must establish that such injuries resulted from a breach of duty which the defendant owed to the plaintiff.
Ayan, na-explain ng maayos ng ating participant ang sagot kung bakit true ang sagot sa number 1. And our scoreboard shows that Miss Colleen is our number 1 top scorer from our participants. Let's go to the next question. Guys, get ready. There are 6 kinds of damages. Is that true or false? 6 kinds of damages in terms of what? Torts damages. Yan, sagot na mga participants. Lahat sumagot ng true. Parang hindi talaga luto tong laban at laro na to. Talagang nag-review lang kayong mga participants natin, am I right? Pero bakit? How many damages? Okay. Hindi ko pa nasabi kung ano yung price. Ang price po natin for today's video is shirt ni Lenny. And who will explain this question?
Mama ko po.
Okay. Yung pabibo natin ng taon. Anong pangalan natin, ma'am?
Oyster po.
Okay, pabibo oyster. Please explain why.
So the statement is true because damages may be actual or compensatory. Number 2, moral. Number 3, nominal. Number 4, temperate or moderate. Number 5, liquidated. And number 6, exemplary or corrective. In actual or compensatory, indemnification for damages shall comprehend not only the value of the loss suffered, but also that of the profits that the obligee failed to obtain. It is meant to compensate for the injury inflicted and not to impose a penalty. On the other hand, moral damages as physical suffering or refers to moral damages as physical suffering, mental anguish, fright, serious anxiety, wounded feelings, moral shock, social humiliation, and similar injury. And for the third kind of damages is nominal. Nominal damages are adjudicated in order that a right of the plaintiff which has been violated or invaded by the defendant may be vindicated or recognized, and not for the purpose of indemnifying the plaintiff for any loss suffered by him. For the next kind of damages, temperate or moderate. Temperate or moderate damages, which are more than nominal but less than compensatory damages, may be recovered when the court finds that some pecuniary loss has been suffered but its amount cannot, from the nature of the case, be proved with certainty. And the next kind of damages is liquidated. In liquidated, damages are those agreed upon by the parties to a contract to be paid in case a breach thereof. And the last kind of damages is the exemplary or corrective. Here, the damages are imposed by way of example or correction of the public good, in addition to moral, temperate, liquidated, or compensatory damages.
Ayan, na-explain ng maayos ni Ma'am Oyster ang ating katanungan. Scoreboard shows that Miss Pauline is still our number 1 scorer, followed by Miss May and Miss Shirley. Okay, all right. Let's go to the next question, please. True or false? There are 3 distinct kinds of actual or compensatory damages. Is that true or is that false? May nagkamali ngayon. At sa wakas may nagkamali na rin. 4 sumagot ng false at 4 sumagot ng true. So, the answer to this question is false. So, bakit kaya false? Who among our participants would like to explain this question? Makakakuha ka ng 2 joints. Courtesy of Ma'am Pachonga. Sino? Okay. Meron tayong participant na nag-raise ng hands. Miss, what's your name?
Rhoda po.
Okay. Explain your piece.
So, generally, damages may only be claimed if the amount suffered must be proven with reasonable degree of certainty, premised on competent proof, on the best of evidence obtained by the injured party, which usually means official or valid receipts. Therefore, Article 2200 of the Civil Code provides indemnification of 2 kinds of damages, which are first, loss suffered or actual loss, or loss for what a person already possessed, which is known as actual damages. And second is the unrealized profits, or the profits which the complainant failed to obtain, or the failure to receive as a benefit that would be pertained to him by reason of breach of contract or as a result of a commission of quasi-delict. So I would like to add, in relation to Article 2200, the Article 2201 of the Civil Code provides damages that are recoverable under contracts and quasi-contracts, which may either be in the form of the general or special damages. So under the general damages or ordinary damages, these are presumed or implied, for they are natural and necessary result of the wrongful act or omission asserted as the foundation of the liability. So these damages refers to those identified under Article 2200 of the Civil Code, which are actual or compensatory damages. However, Article 2201 likewise add special damages, which are necessary results from the injury and are not implied by law, for it is only found in case where some external condition apart from the actual term to the contract ceases or intervenes. However, there must be an actual notice of such external condition which made the damages possible, or the likely consequence of the breach was known to the defendant at the time the contract was made, must be established before one may be liable for damages for these special damages. That's all.
Thank you, ma'am, for that very, very informed answer. Medyo nahilo yata ako sa may pa-article ni madam. Hulak ko law student to. And our scoreboard shows that Ma'am May is still our top scorer, followed by our rising Sir Henry. And Miss Sherin is on fire. He has the highest answer streak of 3. So, let's see kung sino yung top 1. Kung may makakalampas ba kay Miss May sa susunod na tanong. True or false, natural and probable cause involves two things, casualty and adequacy. Is that true or is that false? Okay. Malapit na akong maniwala na lahat ng participants natin ay babae kasi karamihan sa kanila ay laging tama. Wala ba sa ating mga participants ang makakapag-explain as to why this question is true? Kung wala, ako na lang sasagot. Kasi pabibon ako kagaya ni Miss Oyster. So, when we talk about the extent of liability in terms of in crimes and quasi-delicts, defendants are usually held liable for damages when such damages are natural and the probable consequences of the act or omission complained of. So, regardless if such damage have been foreseen or could have been reasonably foreseen by the defendant. So when we talk about natural and probable, it actually involves two things, casualty and adequacy. Because casualty means that the damage would not have resulted without fault or negligence of the defendant. And adequacy means that the fault of the defendant would normally result in the damage suffered by the obligee. So, a person would be held liable for the injuries sustained by those who may be considered as unforeseeable plaintiffs. That means to say that the defendant is liable not only to the person to whom the negligent act was directed, but to the persons who may be directed, but even to third persons. So, kung hindi niyo pa na-explain, I will illustrate it for you guys because I'm super duper prepared. For example, defendant may be held liable for damages to third persons, or this is otherwise called as indirect damages. And those third persons who are dependent for support upon the injured party may recover damages. The reason behind this is because these third persons cannot be considered as foreseeable plaintiffs at the time of the occurrence of the negligent act or omission. So, yun lang naman yung very, very short explanation as to why natural and probable cause involves casualty and adequacy. Now, on to our scoreboard. Wow! Mr. Henry surpassed Miss May and is now the person on fire. Wala na si Ma'am Sherin, baka natugpo na yung apoy niya. Let's see, for our next question, who will remain in top 1. True or false, the amount of damages for death caused by a crime quasi-delict shall not be at least 3,000 pesos. True or false? Okay? May isa lang na nagkamali. And all of the rest answered false. Why is it? Why is it false? Can someone from our participants from the outside world explain?
Okay.
Okay,
Hello?
our top scorer is answering for today's video. Okay, sir, take the stage.
My name is Enveloy D. Catugas from Calasiao, Pangasinan, representing the male gender in this competition. So I would like to explain this question. So the question is, the amount of damages for death caused by a crime of quasi-delict shall not be at least 3,000 pesos. This is false because under Article 2206 of the Civil Code, the amount of damages should be at least 3,000 pesos for quasi-delicts, not less than 3,000 pesos, regardless if there are many mitigating circumstances. Another addition to this is that Article 2206 provides that the defendant would be liable for the defendant will be liable for the loss of earning capacity of the deceased to be paid to the heirs of such deceased. Also, if the deceased was obliged to give support according to the provisions of Article 291, or those persons mutually obliged to mutual aid. Okay. Both moral and material shall be rendered among members of the same family member. And that would be all.
Yung akala mong okay na, you can switch to something better pa pala. Introducing the new and improved Nescafe Creamy White. Ngayon, dinagdagan ng Nescafe Coffee. May creaminess pa ng Nestle Milk. Kaya lasap na lasap at tumatagal ang sarap. Mapapaswitch kaya na snack sa new and improved Nescafe Creamy White from Nestle.
Nagbabalik po kayo sa aming programa na Game Ka Na Ba? And now, our scoreboard shows that Mr. Henry is our top scorer for today's video. And Miss May has the highest answer streak of 5. Let's see kung matatanggal ba si Henry sa kanyang top 1 seed. Next question, please. True or false? Plaintiff must allege the basis of his claim for attorney's fees in the complaint. Is that true or is that false? Yes. Tama talaga. Tama talaga ako, promise. Na halos lahat ng player natin ay babae at may nag-iisa lang na lalaki dahil halos lahat kayo ay laging tama. And why is this? Can someone from our participants explain this question? Okay, a participant from the outside world, Miss Hilario, you may now take the
Yes,
stage.
ma'am. Plaintiff must allege the basis of his claim for attorney's fees in the complaint. The basis should be one of the cases under Article 2208. Article 2208 states that in the absence of stipulation, attorney's fees and expenses of litigation other than judicial costs cannot be recovered except, first is when exemplary damages are awarded, second, when the defendant's act or omission has compelled the plaintiff to litigate with third persons or to incur expenses to protect his interest, third, in criminal cases of malicious prosecution against the plaintiff, fourth, in case of a clearly unfounded civil action or proceeding against the plaintiff, fifth, where the defendant acted in gross and evident bad faith in refusing to satisfy the plaintiff's plainly valid, just, and demandable claim, and sixth, in actions for legal support, seventh, in actions for the recovery of wages of household helpers, laborers, and skilled workers, And number 8, inactions for indemnity under workmen's compensation and employer's liability laws. And 9, in a separate civil action to recover civil liability arising from a crime. 10, when at least double judicial costs are awarded. And lastly, in any other case where the court deems it just and equitable that attorney's fees and expenses of litigation should be recovered. So in all cases, the attorney's fees and expenses of litigation must be reasonable.
Ayan. Very competitive ang ating participants for today. Laging handang mag-explain. Wala pala akong nasabing reward, no? Kung may gusto kayong reward, you may proceed to Ma'am Bumilaw for your reward and freebies. And our scoreboard shows that Mr. Henry is still our top scorer. Now, let's proceed to the next question, please. True or false? There is only one type of interest. Is that true or is that false? Yan. May isa lang na nagkamali. Hulaan nyo kung sino yan. Can someone from our participants explain the context behind this question?
Again po.
Ay! May pumapangalawa sa ating Padibo Girl Oyster, si Miss Hilario. Okay. Explain.
Yes, ma'am. There are two types of interest. The first one is monetary interest. It is the compensation for the use of money. The legal rate at the time of perfection of the obligation will apply. It will not be affected by a supervening change in a legal rate of interest. The requisites are as follows. The collection of interest in loans or forbearance of money is allowed only when these two conditions concur. First, there was an express stipulation for the payment of interest. And second, the agreement for the payment of the interest was reduced in writing. Absent any of these two conditions, the money debtor cannot be made liable for interest. Evidence must be presented to show that the parties agreed to the payment of interest. So the second type is compensatory interest. It is awarded in the concept of damages for the delay in the performance of an obligation. It is due and demandable from the time demand is first made, whether judicial or extrajudicial. For compensatory interest, the legal rate of interest always applies. This means that compensatory interest is affected by supervening changes in legal rate of interest. That's all, ma'am. Thank you.
Right. Lumalaban pa din si Miss Hilario. Now, our scoreboard shows that Mr. Henry is still our top scorer. Let's all cheer for Miss May for the next question. Okay, true or false pa din. When the obligation is breached and it consists the payment of the loan, the legal interest always applies. Is that true or is that false? Choose your answer wisely. Ayan. May isang tumama. Hulaan babae yan. Can someone from our outside world participant explain this question?
Game na game.
Hi! Nagbabalik. Nagre-resurrect. Ang wala iba, kundi ang ating pabibong, si Miss Oyster. Paki-explain po yung tanong na ito.
Okay, so the statement is false because when the obligation is breached and it consists in the payment of a sum of money or a loan or forbearance of money, the interest due should be that which may have been stipulated in writing. And the legal interest only will apply if there is no stipulation. And when an obligation not constituting a loan or forbearance of money is breached, an interest on the amount of damages awarded may be imposed at the discretion of the court at the rate of 6% per annum.
Is that it, Miss Oyster?
Yes po.
Okay. Thank you for that very, very wonderful answer to our very, very wonderful question. And from our scoreboard, may lumalaban. Sino kaya to? Ang tali-talino naman netong lumalaban. And Sir Henry is still our top scorer. Let's see sa ating next question kung sino pa din ang uuwian. In quasi-delicts, the contributory negligence of the plaintiff shall not produce the damages that he may recover. Is that true or is that false? Choose your answer, guys. Okay, may tatlong tama at may tatlong mali. Can someone from our participants help me explain the rationale behind this question?
Yes po, Madam Charot. Ako po yung nakakuha ng correct answer.
Ay,
Charot.
okay.
Right? The answer here is false because it is provided for in Article 2214 that in quasi-delict, the contributory negligence of the plaintiff shall reduce the damages that he may recover. Here, the court has no discretion. It shall reduce the damages that the plaintiff may recover, which is a mandatory order. Take note that its use in the law denotes an imperative obligation and is consistent with the idea of discretion. Yun lang po.
Ito na at ang pinakamahaba explanation na narinig ko sa ng buhay ko. Thank you for that, Miss Pachonga. And our scoreboard shows that Mr. Henry is still our top scorer, which is... okay lang. Let's see sa ating next question kung sino pa yung maging top scorer. Okay? It cannot arise until a cause of action has accrued which will entitle the plaintiff at least 2 nominal damages. What is... choose. Ito ang ating elimination round. Ito na yung ating final question. Kaya choose your answer wisely, guys. Which among these options is the correct answer? Okay, time's up. Everyone got the correct answer. Nag-review pala kayong lahat. Very good. Very good yan, guys. Can someone, again, explain this question?
Ako pa rin, ma'am.
Ay, may lumalaban kay Miss Oyster at Miss Hilario, si Miss Pachonga. Okay, take the stage.
Yes, the doctrine of avoidable consequence defined, as a defense cannot arise until a cause of action has accrued, which will entitle the plaintiff at least to a nominal damages. Doctrine of avoidable consequence as opposed to a doctrine of contributory negligence. This doctrine must be based upon the plaintiff's obligation or duty under the contract or its incident. So, take note that it must be antedate or concurrent with the latter.
Ayan. Na-explain ng maayos ni Miss Pachonga ang ating sagot. And our top 2 is walang iba kundi si Miss Keith at ang ating reigning king for the game ka na ba is Mr. Henry. At ang iyong prize, Mr. Henry, ay isang unsolicited advice. Vote wisely. Thank you po sa pakikinig sa ating game ka na ba? See you po sa ating susunod na...
Yung BBM tarpaulin kayo.
Okay. Thank you kay Miss Pachonga. I-claim mo daw ang poster kay Miss Oyster. Thank you sa pakikinig sa ating kalaro for today's video. See you again sa susunod na ating programa.
Everyday sa bahay daming activities, kaya breakfast pa lang give them champion energy.
Milo breakfast every day, Milo breakfast every day helps you jumpstart your day. Milo every day.
Help make breakfast more nutritious with Milo. May winning combination ng milk, champion energy nutrients, at choco multi-sarap.
Milo breakfast every day, Milo breakfast every day helps you jumpstart your day. Milo every day.
From Nestle.
Ang programang ito ay rated SPG. Striktong patnubay at gabay ng magulang ang kailangan. Maaaring may masiselang tema, lengguwahe, karahasan, sexual, horror o droga na hindi angkop sa mga bata.
Dear Tita Charot, ako po si Juan at ang aking asawa ay si Maria. Meron kaming 3 mga anak. Si Sarah ang aming panganay, si Ruth ang pangalawa at si Esther ang bunso. Nakatira kami sa isang simpleng tahanan sa Zambales.
Mga anak, nakauwi na ako.
Andito na si Papa. Papa, pasalubong ko po.
Siyempre naman, mga anak, mamaya ko ibibigay sa inyo ha.
Oh, love, nakauwi ka na pala.
Na-miss mo ba ako, love?
Oo naman. Ang sweet.
Mama, Papa naman, baka lang gamin kayo niyan ha.
Magkakaroon na ba ng bagong bunso? Esther, kabata-bata mo pa, ang dami mo nang alam ah.
Bakit mga anak, gusto ninyo ba? Maglaro muna ako sa labas at baka magkakaroon ng bagong baby.
Sige, tagu-taguan. Yay!
Naglalaro po noon ang aming mga anak sa may kalsada nang di ko sukat akalain na dahil sa insidenteng ito ay magbabago ang buhay ng aming munti at masayang pamilya.
O, tagu-taguan tayo. Si Ruth ang taya.
Ala, ang taya naman ni ate. Dapat ikaw. Ikaw na kasi ikaw yung pinakamatanda.
Oo nga ate, magaling ka kasing magtago. O sige na nga.
Yehey!
Tara na, pagtago tayo. Tagu-taguan, maliwanag ang buwan. May 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Nandyan na ako. Naku, gabi na. Asan kaya si Ruth at Esther?
Pre, tignan mo yun batang-bata.
Mang Juan yan, menor de edad pa yan.
So ano naman, ayaw mo?
Sinabi ko ba? Tara na. Nene.
Ano po yun, Mama?
Pakis nga ako.
Ayaw ko nga, ang tanda-tanda nyo na. Kamukha nyo pa si Smigol.
Bastos tong batang to hawakan mo.
Halika dito.
Wag po!
Huwag ka nang pumalag.
Wag po, parang awan nyo na po. Hindi niya na po kamukha si Smigol.
Huwag kang mag-alala, mag-enjoy ka din.
Mga moms!
Mag-free pataas!
Bigyan sila ng Bonakit Preschool 3 Plus. Sadyang ginawa para sa mga batang free pataas. Yan ang gatas ng
Batang may laban!
Dati may kumakain ng fita. Kaso may nalimos na lola. So, hinatian niya. Diwata pala si lola.
Dahil busilak ang iyong puso, isang kahilingan.
Sagot si kuya. Sports car! Ulit! Half fita, half kotse.
Balikan ng tamis alat sarap ng fita. Balikan ng sarap.
Gabi na, nakauwi na ba ang mga bata?
Oo, nakauwi na si Ruth at si Esther.
Si Sarah.
Ewan ko nga sa batang yun, gabing-gabi na, wala pa.
Tara, hanapin muna natin siya, delikado sa daan.
Pa, Mama.
Anak, anong nangyayari sa iyo?
Ba't ganyan ang itsura mo?
Sila Mang Tonyo at Estores. Minaniyak po ako.
Ano? Mga walang puso, mga walang hiya. Pagbabayarin ko sila.
Juan, saan ka pupunta? Maghunos dili ka.
Maghunos dili. Tignan mo ang ginawa ng mga hayop na yan sa anak natin.
Idaan natin to sa batas. Pagbabayarin natin sila.
Nagsampa kami ng karampatang kaso laban kay Tonyo at Estores. Sobra kong minamahal ang aking mga anak kung kaya't hindi ko maatim ang ginawa nila sa aking anak at ang trauma na sinapit ng aming pamilya. Handa kaming ipaglaban ang kaso ng aking anak upang malabanan ang kababuyan na ginawa nila sa aking panganay. Akala ko, eto na ang pinakamasakit na bagay na sasapitin ng aking pamilya. Subalit ako ay nagkamali.
Insan, ano bang nangyayari sa kapatid ko?
Sinungaling ang mga taong yun. Hindi nagmanyak ang kapatid ko.
Sa tingin ko, gawa-gawa lang ni Juan yan.
Kung gusto mo, Insan, gantihan natin eh. Oh, mga anak, matulog na kayo ah.
Good night
Opo,
po,
Papa.
Papa. O Sarah, ba't di ka pa natutulog?
Di po ako makatulog, Mama.
Anak, huwag kang mag-alala. Nandito na si Papa, walang mangyayari sa iyong masama.
Oo nga anak, huwag ka nang mag-alala. Nandito kami para sa inyo ng mga kapatid mo.
Talaga po?
Ano yun? Walang gagalaw na masama.
Sino kayo? At ba't kayo nandito sa bahay namin?
Pagsisisihan niyo ang ginawa niyo sa kapatid ko.
Ano bang ginawa ng aking pamilya sa inyo?
Na ang huling araw ninyo. Paulan na ng mga bala yan.
Huwag, mga anak.
Sa madugong gabing iyon, ay agad na binawian ng buhay ang aking anak na si Ruth. At namatay din si Esther sa hospital dahil sa kanyang mga natamong sugat. Ako at ang aking asawa at anak na si Sarah na lamang ang natira. Subalit kahit gaano pa man kabigat ang mga natamo naming sugat at pasakit, hindi kami susuko upang makamit ang hustisya para sa aming pamilya. Umaasa kaming maghihilom ang sugat na naidulot ng mapait na ala-ala ng gabing iyon. Nagmamahal, Juan. Sa awa ng Diyos, nakamit ng pamilya ni Juan ang hustisya. Ang mga pumaslang sa dalawang anak ni Juan ay nahatulan ng 2 counts of murder at pinagbabayad ang 3 akusado sa bawat isa sa dalawang namatay ng 100,000 para sa civil indemnity, 100,000 para sa moral damages, 100,000 para sa exemplary damages, at 50,000 para naman sa temperate damages na may tubong 6% bawat nakasaad na klase ng danyos kada taon hanggang sa mabayaran ng mga akusado lahat ng dapat bayaran.